It's possible to pity Sylvester Finbar Nagle. He's one of those rather sad people who aspire to be a lawyer but has never been able to obtain the necessary academic credentials and then admission to practice. In the 1990s, he was taking advantage of a linguistic curiosity. You see, in the United States, a lawyer is known as an attorney. In Australia, we also have attorneys, people who hold power of attorney, but they don't have to be lawyers and they can't practice as lawyers. An attorney in Australia is almost like a guardian. I hold power of attorney for my mum, in case she gets sick and can't speak for herself. Mr. Nagle started describing himself as an attorney. He started representing people as an attorney. He meant that they were giving him power of attorney, but it's pretty clear that many of his victims thought that he was an actual lawyer. The Law Institute of Victoria obtained a court order to stop him from using a name or title implying that he was a solicitor. He didn't stop. He continued to represent clients as a power of attorney, including in correspondence and in court proceedings. He seems to have gotten away with it, at least partly because it's not exactly required that you show your admission certificate in order to stand at the bar table. His deception, though, wasn't great. His written work in particular was basically alphabet soup, strewn with legalish words that he doesn't seem to have understood, and sentences that were incomprehensible at best. Indeed, in this case, the judge quoted verbatim from one of his letters, then said, what all the foregoing meant was anybody's guess. Action was taken for contempt against Mr. Nagle, alleging that he had breached the court order in relation to a number of specific clients. His defence was essentially that he was not doing anything that was exclusively the province of solicitors. The court wasn't having any of this. Justice Phillips said that the rules could be breached by doing something which, though not required to be done exclusively by a solicitor, is usually done by a solicitor, and by doing it in such a way as to justify the reasonable inference that the person doing it is a solicitor. Nagle was convicted of contempt, but still hovers around the fringes of the profession, nowadays as a mediator.